Hello, my name is Ronan Cross, and I am in Quantity Surveying Year 2. This is a presentation for the module Construction Law, and my act is Statute of Limitations Act 1957. My K number is K00227973. The Statute of Limitations Act 1957 was amended in 1991, and again it was amended in 2000. The main purpose for this act is the time limits for making a claim. So basically there's a limit for different litigations for the time which you can make, for the time in which you can make a claim. To discourage delays in making a claim, protect defendants. It will protect defendants from stale claims, and an example of this is Mitchell 2017. In this act, it will ensure that the evidence is fresh for each of the court cases. And it'll predict the litigation as well. The limitation periods vary with each type of litigation. These different the variations for the time periods are personal injury, which is 2 years. An example of this: if a man got injured in the morning, he would have 2 years to claim for injury purposes. Fatal injury is 2 years. Assault is 6 years. Defamation, libel, and slander is 1 year. Actions as a result of breach of contract or quasi-contract is also 6 years. Defective products, 3 years. Defective products would include maybe a car. If a person was to buy a car in the morning and there was a defect in the car, well, whenever that defect had arose, then it is 3 years from when it arises to when you can claim up to. Claims against the state of a deceased person is 2 years. The recovery of land is 12 years. The state authority land 30 to 60 years, and actions in tort is 6 years. There are a number of exemptions in when the claims come into act. Some of these exceptions are a person who is under a disability is when these exceptions will come in. A disability is just something like if an infant or a person under 18, if something happens them, then they can claim until they are over 18. So that's when the limitation period starts. If a person is of unsound mind, so if a person was injured in an accident, God forbid, in the morning, well then until he was of an unsound mind after the accident, well then it would until the limitation period would start when the person would become of sound mind, or also convict. An example of this was the asbestos related injuries with the army deafness. The army were out in war, and with the gun noises they got asbestos in their ears, and they were unable to claim until it was guaranteed what exactly the injuries were, and then the limitation period started when they found out that it was asbestos. So the example really is the personal injury. 2-year period starts when claimant turns 18, and that is only if a person is under 18. Torts is 6 years, so tort is wrongdoing. The wrong causes a claimant, the person making a claim, to suffer injury or loss as a result of some cause of action which results in a legal liability by the person who caused the loss or harm. And an example of this is Fox in 2015. So when the Statute of Limitations Act in accordance with construction, there is the question you have to ask yourself is, when does the clock start? So a construction is a very difficult way, or it is a difficult it's very difficult to say when exactly the time starts in the construction. So, for example, here the plaintiff sued for negligent design of a factory chimney built in 1969, and the cracks of the chimney developed in 1970. They could have been discovered in 1972, but they weren't discovered until 1977. The court held time ran from 1970, when the cracks developed, came into existence, and not the date when damage could, with reasonable diligence, have been discovered, or when the damage was discovered. So this was O'Sullivan in 2013. So they have to be able to, just because they were formed, or that they were discovered in 1977, doesn't mean that the limitation period starts in 1977. It starts in 1970, when the cracks developed. The cause of action. So in construction, it's very hard to say when exactly the cause of action occurred, and it's quite crucial in buildings to see when the damage actually occurred. The latent defects. So a defect may occur during the initial foundation work of the building, but may not be discovered until it is visually seen, until the cause is seen for in later years. So the Irish law has typically rejected the concept that a cause of action does not accrue until the damage is discovered, or is at least discoverable, and this is Mitchell 2017. So the Brandley case 2017, Brandy and WJB Developments versus Dean and Lohan. So March 2014, foundations complete in the building. September 2004, March 2004, foundations complete in the building. September 2004, the building was certified by the science certifier. But in December 2005, which is nearly 15 months after it was certified, the cracks were discovered. In November 2010, which is just short of 5 years later, proceedings issued. If another 5 years later, so 10 years from when the cracks were discovered, the High Court, the claim was statute barred. February 2016, the Court of Appeal overturned High Court ruling. So in November 2017, Supreme Court upheld Court of Appeal decision. Unanimous decision of 5-judge Supreme Court, referred to Hegarty versus Loughran. Chief Justice Finlay stated, "A tort is not completed until such time as damage has been caused by a wrong. It must necessarily follow that a cause of action in tort has not accrued until at least such time as two necessary component parts of tort have occurred, namely the wrong and the damage. In other words, the cause of action does not accrue until some damage occurs." So this case was went to the Supreme Court, and it was actually given the all clear, and Brandley and won the court case. Now, thank you for watching my presentation, and have you any questions here today? Thank you very much.